Hello, Dale Carson, attorney, Jacksonville, Florida, author of the book Arrest to Prove Yourself. We've had a few questions pop up about the law, and I wanted to discuss with you this real sort of oddity with Miranda. Most of us know what the Miranda warnings are. They say, essentially, you have the right to remain silent. Anything you say can and will, both operative words, be used against you, and you have a right to a lawyer. That's pretty straightforward. And we would generally think that everybody should be advised of those rights before you talk to law enforcement. And as a rule, that works pretty well. If you're the target of an inquiry and you're going to be arrested or there's probable cause to arrest you, law enforcement's obligated to give you that warning. But they give it to you in such a way that you almost feel thankful that they gave you the warning, but you don't have anything to hide. After all, you're an American. And so you talk, which puts you in tremendous harm's way. That's something you'd never want to do. And under a 2013 case called Salinas v. Texas, the Supreme Court made this odd ruling. Salinas went down to the sheriff's office to kind of avoid being targeted in a homicide case. And because he was there voluntarily and he wasn't a target of an investigation, they started interviewing him. And they didn't advise him of his rights. Even though I've got to be candid, I don't think the advisal of rights to suspects really stops them from talking, because it's all a matter of tone and delivery and body language, which creates this illusion in suspects that you can talk with impunity and the officer, after all, is simply there to help you. But in this particular case, they asked him and he gave a long statement, and then they asked if they could check his shotgun and would it have shell casings in it similar to the ones that were found at the scene. And he didn't say anything at all. He just got really nervous. He bit his lip. He started sweating and shuffling his feet. He wouldn't think much about that. So he went on about his business, having not said anything. And later he was picked up on a traffic violation and they charged him with, get this, murder. And the Supreme Court ruled that that was okay, that his physical actions could be reported, and in fact were in this case. We don't know at this juncture whether or not he was actually later convicted of the homicide, but that's really not the point. The point is, even if your lawyer is sitting with you, I can't prevent my client from reacting to a question put to them by law enforcement. Did your client kill somebody? And there you are sitting, the sweat's pouring off your face, and you've got dry lips. I mean, come on, if that can be used against you, that hurts you. And no, it's not testimony in the sense of an oral statement. It's still a lead for the government to use. So even if your lawyer is present with you when you've been accused of a crime, you shouldn't be there. Your lawyer can certainly be there by herself, but you shouldn't be there for those very obvious reasons. The law is changing every day. Tomorrow there'll be something different. You owe yourself the benefit of understanding the law so you don't just accidentally put yourself in harm's way. And you do that by having somebody you talk to who is a competent lawyer who can protect you, particularly if you get a phone call from law enforcement saying they want to talk to you. Because the answer to that is, let me check, I will get back to you. Not, oh, no problem, I'll be right down. We sometimes, as good people, believe that if we go down and talk to law enforcement, we are going to be able to avoid a potential criminal charge. But I can assure you, if they're talking to you, you are a potential target. Even if you're a witness. It's not so long ago that I had a client sitting right in this office whose boyfriend was a fugitive. And she was asked by law enforcement whether or not they'd had any communication, which she denied. I didn't deny it for her. She denied it. It was later determined that she had been in electronic text messaging communication with the fugitive. And the Jacksonville Sheriff's Office charged her as an accessory. So you've got to be very careful when dealing with law enforcement. About the only time you ever need their help And you don't have to worry about what you're saying is, my friend's drowning in the ditch over there, please rescue him. Or that house is on fire and I think there are children inside. That's probably not going to get you in trouble. But if you start talking about something in which you are a direct witness or you are a possible suspect, you're doing yourself an extreme disservice. So, answer, have somebody on speed dial that you can call and ask those questions to. If you have questions about this or other matters, or if you have things that relate to ongoing news articles or situations that have happened you want a little clarification on, don't hesitate to give us a call. We're always happy to get on Facebook Live and chat with our friends in the internet. Have a safe day, and I look forward to hearing from you.